And welcome back to Beyond the Breathalyzer. Last time, we discussed the Supreme Court's jurisprudence, again, just a fancy word meaning past decisions, involving illegal or prolonged detention. Those cases necessarily assume that the stop was legal and therefore constitutionally compliant. So the court wasn't focused on whether the officer should have stopped the car or should have engaged a citizen, but instead on what happened after the stop and whether the officer has a legal and justifiable basis to keep the citizen detained. The most recent decision in our case for today is Rodriguez versus U.S., a 2015 case out of Nebraska involving a minor traffic violation, a drug-sniffing dog, and a prolonged detention. My name is Shelley Behan, and this is Fourth Amendment Friday. Rodriguez was pulled over for a minor traffic deviation, driving briefly on the shoulder of the road. The officer, for reasons not specified, requested a drug-sniffing dog report to the stop. He then walked to the window of the car and engaged Rodriguez, began small talk, requested to obtain the necessary documents from him, returned to his car, ran a records check, walked back to the vehicle. He then requested documents from the passenger, returned to his car again, ran another records check, and walked back to the vehicle a third time, reportedly to issue a warning. At this point, the officer then returned all of the documents that he had obtained. The officer later testified at a suppression hearing that he had, quote, taken care of all the business for the stop, but he did not consider Rodriguez free to leave. Instead, he asked for permission to walk the dog, who at this time had arrived, around Rodriguez's vehicle. The dog, of course, alerted. The meth, of course, was found. Rodriguez, of course, was indicted and moved to suppress based on an illegal detention. The motion was denied at the trial court, and the denial was affirmed by the 8th Circuit, finding the 7 or 8 minute delay in the case was a de minimis, which is Latin for minor, intrusion, rejecting the 8th Circuit's contention that constitutional violations might be measurable in minutes. The Supremes reversed. A seizure remains lawful, wrote the court, provided that the length of the detention lasts no longer than necessary to complete the purpose of the stop. Since the officer had diligently pursued the purpose of the traffic stop, issued the warning ticket, and returned the documents, any ongoing detention was unjustified without reasonable suspicion of criminal activity. Dog sniffs on your search, the government protested. Don't care, says the Supremes. You don't have permission to hold people at the scene of a traffic stop without reasonable suspicion of criminal activity in the hopes that you somehow develop reasonable suspicion of criminal activity or probable cause. In other words, a traffic stop cannot be extended in duration or scope beyond the initial purpose of the stop without independent, reasonable suspicion of criminal activity. The police simply cannot keep you by the side of the road doing test after test to develop some sort of suspicion you're engaged in criminal activity. We see this a lot in DUI cases. If the officers don't have sufficient suspicion to justify the initiation of a DUI investigation, the law requires them to pursue the basis for the stop and then send the driver on their way. We'll be discussing that idea a lot more in the upcoming season of Beyond the Breathalyzer, so be sure to subscribe to not miss any updates on when the first season will be released. And that wraps up part 2 of Rodriguez versus U.S., the prevailing Supreme Court precedent regarding illegal or prolonged detention. Tune in next time when we will be discussing what happens when officers really want to search your car, so they decide to pull you over for the slightest little thing. It's called a pretext stop, and we'll talk about it next time on Fourth Amendment Friday. Until then, stay free, stay fabulous, and remember your fundamentals. My name is Shelley Behan. I'm the host of Beyond the Breathalyzer, and your rights are my priority.